I'm going to be talking about some of the basics of contract drafting in this video. And what I'm trying to make up for as I talk about contracts is the fact that probably for most of you, the only experience or exposure you've had to contracts is in your first year contracts class. And what lawyers actually do with contracts is far different from the things that you learned in your first year class. Let's start by focusing on why it is that we consider contracts so important in the context of doing business transactions. Contracts serve two primary purposes in the context of a business deal. Number one, they create a roadmap or blueprint of the business relationship between two or more parties. They set forth the ground rules. Everyone understands what it is they're required to do and what they are entitled to expect the other parties to do. The second main purpose of contracts is to anticipate and preclude disputes between the parties. And we do that by getting the parties to all think about difficult issues and agree in advance on what happens if things don't work out the way they should. And secondly, we do that by being as precise as possible when we're drafting contract language, because the more precise the language is, the less the likelihood that one of the parties is going to be able to argue that the intent of the parties or that the meaning of the contract is different than what the parties really intended. Let's look at a couple of the ways that contract drafting is different than the other kinds of writing that you're used to doing. And in an earlier video, I referred to this as one of the four big differences between doing deals and doing litigation. So I've got a series of slides here which illustrates the difference between contract drafting and other kinds of writing. Let's start by talking about the kind of writing that you do all the time, that you've done since you were in kindergarten or first grade, that your law school writing class taught you to do in the legal context, that is drafting briefs and memos, and that's expository writing. And the basic paradigm of expository writing is, on one side, you've got a writer, and here in this slide, the writer is this gentleman on the left, and you can see that he has a brain. And what expository writing is basically an attempt by the writer to transmit something from his or her brain into the brain of one or more readers. The writer is either trying to inform or persuade or entertain or ask a question, but in any event, they're taking something that's in their head and they're trying to convey it into somebody else's head. That's the basic paradigm of expository writing. Now let's see how contract drafting is different from that. In contract drafting, you'll notice that the first step here is not a one-way arrow, but a two-way arrow, and that two-way arrow represents the meeting of the minds, which I know is something you learned about in law school or heard about in law school. But this is a very important aspect of getting a deal done, because in many cases, the business people will say they have a deal, and they may not have a complete deal. They have not fully fleshed it out. It's our job as lawyers, and this is one of our most important tasks, to get the business people to in fact have a true meeting of the minds, for them to think about and address some difficult issues that they'd probably rather not think about and address. And then when there is a meeting of the minds, it's our further job then to record that meeting of the minds in words in a contract, and do that in a way that ideally is so clear and so precise that not only are the parties to the contract going to agree, yes, those words accurately reflect our deal, but those words will also be written so clearly that each future reader of the contract will interpret the contract the same way. That's our ultimate goal, and we'll be talking in this video and later when we meet about some of the reasons we can't always quite achieve that level of absolute precision. Now let me turn the subject to a very serious topic, which is the issue of plagiarism. And you have no doubt heard for many years in your academic career about how serious plagiarism is, how it's to be avoided at all costs, and the terrible consequences of plagiarism if it's discovered. Now I have good news for you. As it relates to drafting contracts, you can forget all of that, because in this context, plagiarism is good. Not only is it good, it's an important skill. You are going to need to become an effective plagiarist. And this is because when we're drafting contracts and most other deal documents, we are not starting with a blank piece of paper. We're not creating a work of art. We're starting with a precedent or a model, a form of the agreement that you're going to be putting together. Now I want to talk briefly about what I call the building blocks of contracts. These are 4 basic kinds of contract provisions that you're going to see in most contracts that you work on. We are going to be talking about each of these in greater detail when we meet in Chicago, but I wanted to introduce them all to you so you could just start processing the concepts in your brain. These are provisions that are not relevant to any particular kind of transaction. You see them everywhere, and they generally perform the same legal and business purposes regardless of the type of contract they appear in. So the 4 types of provisions I'm going to be talking about are reps and warranties, conditions precedent, covenants, and endgame provisions. First, let's talk about representations and warranties. And you will notice that on the slide, and as I talk about them, I shorthand this cumbersome phrase to the word representations. There is a technical difference between a rep and a warranty, but we're not going to get into that now. So what is a representation? Very simple. A representation is a statement of fact made in the contract by one or more of the parties to the contract that speaks as of one or more facts as of a specific point in time. And that's a very important concept. Reps are a snapshot. They state facts as of a moment. The statement doesn't need to be true at all times. It just needs to be true at the moment that the rep is made, which is almost always at the time the contract becomes effective. Although we'll be talking more about some modifications of that concept a little bit later. So representations basically cover facts that one of the parties cares about and is relying on in entering into the deal, where that party is saying to the other party, the party who's going to be giving the reps, listen, I'm relying on these facts and I want you to kind of stand behind these facts by making these representations in the contract, so that if it turns out that the representation wasn't true when you made it, I'll have some recourse against you or some remedy under the contract. Here's an example of a rep that's going to appear in the stock purchase agreement between Baron Wuffett and Clothes Kingdom. Baron Wuffett's lawyer, who's going to do the first draft of the stock purchase agreement, is going to put in this rep in which Clothes Kingdom states that it has good title to the shares of Boxy Suits that it's selling to Baron Wuffett. And this makes absolute sense, right? Whether or not the owner of the shares who's selling them, in this case, has good title to those shares, is the true owner of those shares, that's a fact that a buyer is always going to care about. So we would expect to see a rep like that in this purchase agreement. The next basic kind of contract provision I want to talk about is the condition precedent. And conditions precedent are provisions in a contract that say something has to happen, some document needs to be delivered, some action needs to be taken, some state of facts must exist before either the closing occurs or one or more of the parties is obligated to perform. Here are a couple of conditions to the buyer's obligation to buy that are set forth in the stock purchase agreement. Let's start with the second one first. The second one is less sexy, at least in my view. The reason the second one is much less interesting or sexy is because this is an absolutely standard closing condition. You're going to see a closing condition like this in, I would guess, pretty much every deal that you ever work on. And we'll be talking more about what this rep is all about in a different section, but it's about whether the seller as an entity has done everything it's supposed to do under corporate law to decide to enter into this transaction and to authorize the transaction. And in this case, what that means is it means that its board has adopted a resolution to that effect. And so buyers saying, I want at closing you, seller, to show up at closing with some piece of paper, some document that shows to me that your board has actually taken this action. That's a very, as I said, very customary closing condition. Now let's look at the first one, which I referred to earlier as sexy. And the reason I referred to this one as sexy is because this is a closing condition you can actually read about in the Wall Street Journal. And at this point, you might be thinking to yourself, gee, Fox's definition of sexy is way different than mine. And of course, it probably is. But let me talk about this condition. This is the so-called material adverse change, or MAC condition. And it's designed to give the buyer an ability not to close if the target company deteriorates. And even though the buyer is going to protect itself against bad things happening between signing and closing in various ways, including with reps and with covenants, which we'll talk about in a minute, this is kind of a catch-all. And back in 2008, when the financial crisis occurred, and you were probably all in college then, and you knew what was going on, but believe me, at that time, as a finance professional, I really thought the world was coming to an end, and many other people did as well. So in the period immediately prior to the collapse of the market bubble, there were a large number of deals getting negotiated and getting signed up. And the way acquisitions are structured, and you'll see a timeline here, is that the contract gets signed on one date and the closing doesn't actually occur until some date in the future, which could be a couple of weeks or a month later. So what happened was there were many of these deals that had gotten signed up when the bubble was still building and hadn't gotten closed when the bottom fell out. Now, let's assume that this transaction, our transaction, was one of these transactions that straddled the financial meltdown. Buyer has signed a contract saying that it will pay $220 million for Boxy Suits. because it believed Boxy Suits was worth $220 million during the heady times that the contract was signed. But as soon as the financial crisis hit, Boxy Suits wasn't worth $220 million anymore. In fact, you probably couldn't have found anybody to buy it at any price. But let's just say that the more accurate valuation of Boxy Suits immediately after the financial crisis was $100 million. So here is the buyer looking at the prospect of being forced to pay $220 million for a $100 million asset. So what is it going to do? It's going to go to its lawyers, and this is all before closing, obviously. It's going to go to its lawyers and say, get me out of this. The lawyers are going to go through the contract, primarily the conditions precedent section, and what happened in all these cases was there wasn't any convenient way for the buyers to get out of these deals other than this material adverse change clause. So all of the buyers in these deals asserted that there had been a material adverse change. And what do you think the sellers did? The sellers now had the potential for being able to sell what was now a $100 million asset for $220 million. They were very eager to close. So what they did in response to the buyer's assertion of a material adverse change was to say, that's not a material adverse change because the change that's occurred is a change in the economy and the markets. But at least as of right now, the target company is the same company it was a week ago. And this goes to the issue of how the material adverse change clause is worded. If it only talks about a material adverse change having occurred to this company, I think the sellers had a pretty good argument that no material adverse change had happened to that company yet. It probably was going to happen in the future as the bad economy started to ripple through the financial results of that target company, but it hadn't happened yet. So anyway, buyers and sellers started fighting over whether the material adverse change clause applied or not, and ended up going to court. Material adverse change is a kind of provision which we're going to be talking about more in the future, which is not clear. The case law on material adverse change is very confusing and not helpful at all in determining what that phrase means. And the whole concept of materiality is one that by its very nature is fuzzy around the edges. So there's room for parties to dispute what it means, which is what happened here. But while the litigators were fighting this fight in the courtroom, the business people and the lawyers were in another conference room renegotiating the purchase price. And that's what happened in most of these deals, is the deals were recut on different terms, reflecting the fact that none of the parties really wanted to bring the litigation to conclusion because there's too much risk associated with that. Okay, the third kind of building block provision is the covenant. And a covenant is merely a promise to do something, or a promise not to do something, or a promise to maintain a certain level of financial performance or condition. Here's an example of a covenant that we will see in the Boxy Suits stock purchase agreement. This is a covenant that the seller is making, that Closed Kingdom is making, and it's making it because not that it wants to, it's not going to make promises it doesn't have to give, but the buyer is saying, you need to give me this promise, and this is a very standard provision, so Target's not going to fight it. I'm sorry, the seller's not going to fight it. This is a promise by the seller that it won't permit the target to pay any dividends between the time that the contract is signed and closing. Couple of points here. Number one, remember, in a stock purchase agreement, the target company is not even a party, and therefore is not going to be able to give that covenant directly, but there's no reason why seller, since it controls the target, can't make this kind of agreement. That is, it can agree to cause its subsidiary to act in a certain way, and the phrasing here says they will not permit it. Another way to phrase it is, it would have been to say, seller will cause target not to pay dividends, and it could really be worded either way. Why does the buyer care about this? Why do they want this covenant? Well, because they are agreeing to pay a purchase price for the target based on the value of the target's assets. And if a dividend were to be paid, and dividends can either be paid in cash or can be paid in assets, if without this covenant there would be nothing to prevent the target from paying a large dividend up to the seller, causing the value of the target to decrease by a like amount. And so buyer insists on this covenant in order to protect against that act, which would result in a diminishment of the value that the buyer is going to get when it buys the company. The last of the 4 building block provisions are the so-called end game provisions. And these go in a couple of different directions, and but they're all aimed, as the name would suggest, at what happens at the end of the contract. One type of provision that we're talking about here is a termination provision. Some contracts will specify that the contract terminates on a date certain, or can be terminated by one or more of the parties on a date certain, or on the occurrence of some event. The other kind of endgame provision that we're going to be focusing on are provisions that give parties remedies in the event that the other party or parties to the contract have breached or have done something wrong under the contract. So we're going to be talking about remedial provisions. And then one more aspect of endgame provisions are the provisions that set the ground rules for when the parties fight with each other, primarily in litigation. You'll have provisions at the end of the contract, usually in the miscellaneous clauses, that talk about things like what law governs the interpretation of the contract, where can the parties sue each other, how can they serve notice on each other in a lawsuit, do the parties waive a jury trial in the event they sue each other, do the parties agree to arbitration instead of litigation. Those kinds of procedural issues are often negotiated and agreed to up front. Here is an example of an endgame provision in our deal. It's the concept of indemnification, which is a very important provision in an acquisition agreement like this one. And it's designed to protect the buyer against many things, including any breaches by the seller. So, for example, if the seller were to have made a representation to the effect that, say, there are no environmental problems existing at the target company, and it turns out after the closing that the buyer discovers, in fact, there are environmental problems, and those environmental problems existed at the time that seller made that rep. So seller has breached its representation or made a misrepresentation, and the indemnification language in the contract says that in that event, buyer has recourse, buyer has a claim against seller to have seller compensate it for any costs that it incurs or any damages that it incurs as a result of the breach or the rep being untrue. So in this example, to the extent it cost the buyer $1 million to clean up the environmental problem, the indemnification clause would give the buyer a recourse against the seller for that amount.